Hey guys, David Robinson here. Welcome to the Lead Sponsor Podcast. We've got another great episode for you today. Really excited to have a securities attorney with us today. As you know, most of our guests are lead sponsors that are on the front lines of putting commercial real estate deals together, syndication deals together. And every so often, I like to bring, I like to bring in an expert from the field that are sort of behind the scenes supporting the lead sponsors in putting these type of deals together. And an experienced SEC attorney is critical to the team that's putting the syndication deal together. And so really excited to have Mauricio Rauld with me on the show today. Mauricio is the founder and CEO of Premier Law Group, a boutique securities law firm. And they focus specifically in Regulation D exempt offerings and educates investors from all around the world on how to navigate the complex worlds of securities laws. And Mauricio is known for taking really complex matters as it relates to securities and making them very simple to understand. And he's a great guy. He's very personable. And he's very knowledgeable about these type of deals. And so really excited to share with you our interview that we had with him. We dive into his background, how he got into the space. And we talk about a few key pieces of the securities deal as it relates to the legal side and how these syndication deals are structured and what you should be looking out for as a passive investor. If you are a passive investor in real estate syndications, he offers up one real key red flag that you should be looking out for if you're placing money with a sponsor of a syndication deal. And then we also talk about, on the lead sponsor side, some of the things that you need to be watching out for as you're structuring your deals to make sure that you're staying in compliance with SEC regulations. So really excited about our interview today, and I know that you'll learn a lot from this episode. So without further ado, Mr. Mauricio Rauld. Mr. Mauricio Rauld, welcome to the show. Appreciate you coming on.
Thanks, David. Appreciate you having me. Looking forward to this.
Yeah, so Mauricio, as I explained in the bio, is the founder and CEO of Premier Law Group, and he specializes in securities and works with real estate syndicators, lead sponsors all over the country. And so really excited to have him on the show with us today. Of course, our normal guests are those that are out there on the front lines doing deals as lead sponsors. But every so often, I like to bring those that are more behind the scenes, really making these transactions a success, and bring them to the front and let them share some insight about their part in the overall transaction. And so, Mauricio, before we sort of dive into some of the nuts and bolts about securities laws from a limited investor standpoint and also the general partner standpoint, maybe just give us some background on you and how you've gotten to where you're at today.
Yeah, well, I've been doing this for a while. I started practicing in 1999, so this is like 24 years now. It's amazing how fast time goes by fast when you're having fun. Starting my career like any attorney dreams of at a really large law firm down here in Southern California. Did a lot of securities work. Just knew, even though it was an amazing firm, knew wasn't for me. Just kind of the lifestyle, the billable hour, that thing. I was like, I can't do this anymore. Ended up working in-house for a group called the Real Estate Guys, Rob and Russ. Probably heard of those amazing guys. Was their general counsel for about 3 or 4 years, and then I just decided to go out on my own. Kept the guys as sort of a VIP client, but that's really when I started focusing on my own law firm. Obviously, when you start a firm, anything that puts food on the table is what you do. But over the years, I've kind of narrowed the practice down, where today it's it's 100% of our practice is real estate syndications. We don't do anything else. If you call me, I've got a good Rolodex, but I'll put you in touch with somebody else. But for the past now, I want to say, since just before my daughter was born, so maybe about 7 years now, 7 or 8 years, we just focused 100% on syndications. And so we do quite a few of these a month. I mean, we do, probably 15 or 20, sometimes 25 a month. And so we do quite a few volume. And so I've just seen hundreds and hundreds, probably not thousands, but I've seen hundreds and hundreds of business plans, deals, and so it gives me a little bit of a unique situation too, of kind of getting a little bit of the insights of looking at everybody's deals.
Well, I appreciate that background, and yeah, obviously you've got a wealth of knowledge, and I love, when we have an opportunity to work with a specialist that's really focused on their craft in a particular niche topic. And so Let's, if we can, we've got listeners that are both passive investors as well as those that are active investors, syndicators, lead sponsors. But maybe let's just start at a broad overview from a legal standpoint. How would you describe, what a real estate syndication is to, a passive investor?
Yeah, it's very simple, actually. In its most simplest term, a syndication is literally the pooling of resources, mostly money, but not always. Sometimes it's credit, it's your relationships, it's your time, anything that you can pool together in order to go buy something. And obviously in real estate syndication, that something is a piece of real estate. And it's usually a larger piece of real estate, because what typically happens with investors is they go out there and they start with single families or duplexes or fourplexes, and they use their own money, they use their own credit, and then pretty quickly they kind of run out of their own money, or they don't want to use other money, or they want to share that, that wealth with other people. And so they go out and actually start pooling resources, getting passive investors in so they can get large deals. And typically with larger deals, you get better economies of scale, you get better tax treatments that you wouldn't be able to get on a single family home. For example, one of the best benefits out there these days is a sort of bonus depreciation benefit, but you need a cost segregation study, and it doesn't make sense to do that on a house, a single family, but it does make sense when you're doing a 20, 30, 50, 100 unit apartment building. So that's the allure for passive investors, is just being able to leverage not only the sponsor, but all the benefits of real estate that really, and the knowledge, obviously, that doesn't really work with a single family. So my job is basically just to make sure that when the lead sponsor is putting that syndication together, they understand that what they're doing is actually issuing securities, which doesn't necessarily make sense intuitively, because you're just buying a piece of real estate. Why are the securities laws involved? Why is the Securities and Exchange Commission, the SEC, involved? I'm just buying a piece of property. But my job is to make sure that they realize that they're selling securities. And when they realize that, to make sure that they're raising the money, raising the capital in full compliance with both federal and state securities laws.
And to follow up on that, there's generally a few ways that these real estate syndications are structured. Maybe if you are willing, give us a broad overview of the different types of structures and maybe some of the nuances between the two.
From a pure structural standpoint, the vast majority of those syndications are set up via an entity, usually a limited liability company, an LLC, where investors actually become members of that LLC. They're actually equity partners. The limited partners contribute the capital, the vast majority, not all of it, because the sponsor does put their own money at risk as well, but it's usually a much smaller percentage. But 80, 90% of the capital is generally brought in by the passive investor, and they actually own units, membership, think of it as stock in the company, in their LLC, so they're called membership units. And so, I may write a $50,000 check. In fact, I do write $50,000 or $100,000 checks because I'm also a passive investor. And in exchange for that, I literally own 1.3% or 0.8 or 2% of that LLC. And because of that ownership, the reason that ownership structure works beautifully is that all of those beautiful tax benefits that the real estate gives us flows through that entity onto my personal tax returns. And so I get the benefit through that structure of everything, all the benefit that the real estate gets to offer. We also do some what we call debt offerings, where the investor, instead of becoming an equity owner or percentage ownership, they'll get a note in exchange. So maybe I put $50,000 and I get a set return, an 8% or 10% or 12%, whatever the return is. The good news is I'm typically higher in the capital stack, so I get priority over the common shares, right? So I get paid first because I'm the note holder, but obviously the negatives are I'm kind of capped at whatever you gave me. So it's kind of a safer investment, but you've also capped my return at 10 or 12%. And of course, because I'm not an owner, I don't get any of those tax benefits. But that's basically the two main forms. And we do sometimes have tenants in common arrangement because there's sometimes 1031 issues, those will pop in, but the vast majority are structured as equity deals.
And from a passive investor standpoint, from a limited partner standpoint, who can invest in these type of deals?
It depends on the exemption, a little technical here, but it depends on the exemption that the lead sponsor chooses. And so let me just back up a little bit. I'll try and keep this as basic as possible. Generally speaking, again, we mentioned that the lead sponsor is in the business of selling securities. It doesn't make sense, but that's what they're doing. Because you're literally buying stocks. It's almost like they're selling you a share in their company. So it does. That's what the security is. But when they sell securities, there's basically I say three things they have to worry about. They have to either register that syndication or that security with the SEC, which we never want to do, or we have to find an exemption to that registration. And it depends on what exemption we select will dictate who can and cannot invest in deals. So for example, probably the most popular exemption is what we call a 506B, which is probably, if you're in the syndication business, you've heard that quite a bit. But a 506B allows a sponsor to accept a limited number of non-accredited investors. And a non-accredited investor is somebody who doesn't have a lot of money or a lot of income, primarily $1 million in net worth, excluding their primary residence, or they've earned $200,000 the last 2 years and a reasonable expectation of earning that or more this year. So 506B is popular because of that, because it allows sort of the mom and pop, that may not have $1 million in net worth. Maybe I make, 60 grand a year and I've got 500 grand in net worth. I can participate. I do have to have, there's a sophistication level. So there's a little bit of due diligence that the sponsor goes through to make sure that the investor is sophisticated. But generally speaking, anybody who's got a little bit of experience is going to be eligible. If, on the other hand, we select the second most popular exemption, which is a 506C, as opposed to the 506B, if we do a 506C, then the sponsor is going to be limited to investors who are accredited. So I have to verify that my investors have $1 million in net worth, excluding the primary residence, or have earned $200,000 the last couple of years with a reasonable expectation of earning that this year.
Yeah, love it. So at a very high level, these deals are securities, right? They're structured as an LLC. The lead sponsor is selling you an opportunity to buy a portion of that LLC and own units of that LLC. And the SEC regulates these type of transactions and deals. And there's generally Regulation D. 506B is a subset of those rules that says, hey, these are the two types of people that can invest in these type of deals. Regulation D 506B and Regulation D 506C. So thank you for giving us that overview. Since we now sort of set the foundation for the general legal aspect of it, I'm interested in hearing from you from a limited partner standpoint. What are some of the challenges or maybe some of the red flags that you think passive investors should be aware of in getting into a syndication deal? Maybe they're the first time, this is their first time getting into a real estate syndication deal. Is there any guidance, direction, warnings, concerns that you might advise a limited partner to be aware of?
Yeah, I mean, putting aside, there's probably a handful of questions they should be asking, sort of interviewing and doing due diligence, which we can talk about in a second. The biggest red flag for me is that when you're doing a securities offering, generally speaking, you're going to see a document that's called a PPM, a private placement memorandum. And this is a document that's very important for the passive investors because it's a document that basically outlines and discloses all of the risks associated with this investment and all the disclaimers and conflicts of interest and whatever, all the skeletons in the closet need to be outlined in that document. And what happens, the red flags that I don't do this anymore, but I used to review other people's PPM, and people would call me clients, say, hey, I'm going to invest in this deal. Do you mind reviewing it? And every so often you'll see a deal where there's non-accredited investors, like we talked about earlier, but there's no PPM to be found, or the PPM is very light, or it's a few pages. I mean, this is a very, you've seen them, David. They're complicated, 30, 40, 50, 60 page documents that disclose everything. And so if you don't see that, that's usually a red flag. In fact, the two times that I actually came across deals where they didn't have a document and they gave some random reason for it, so sort of excuses why it's not doing it. But if they're cutting corners on a PPM, which usually means they don't have a securities attorney, so they're not looking for a professional. They're obviously not looking for your best interest, because just backtrack, the whole point of a PPM is to make sure that you as the passive investor can see all the good, see all the bad, and then you can make an intelligent decision as to whether this is a good investment for you, right? And so if you don't have that information, it's detrimental to you as a passive investor, and it's theoretically, if it's got some red flags in it, it's beneficial for a sponsor to not give you a document that's legally required. So I've seen it where literally whatever excuse came up those two times, that inevitably, fast forward 2 years, I would get calls from those investors and say, hey, this ended up being a fraud, or I lost all my money, or all that kind of stuff. And so that's the number one red flag. If you do not see a PPM, doesn't mean it's the end of the world, because there are certain circumstances where one may not be required, but at least that should be, like you said, maybe a red flag or just a yellow flag that says, hey, why isn't there a PPM? Ask for the PPM, see what excuse they give you. And then at that point, I would definitely be checking in with your, if you've got an investment advisor or representative that helps you, or just your attorney to make sure, is this really legit? Because if they're not using a securities attorney, then that would definitely be a red flag, because now you have no idea what information they're giving you and whether they're giving you all the information that's required. Because obviously, as a licensed attorney, I'm required to make sure that all those disclosures are in there. So yes, I represent the lead sponsor, but my job is to make sure the lead sponsor is following securities laws, which is ultimately beneficial to the passive investor.
And a quick follow-up question to that dialogue. In regard to, I have a lot of private investors in my network, individuals that are out doing their own deals in many cases. And in some cases, these aren't, a 300 to 400 unit apartment building. It may be a 6 to a 24 unit apartment building. And they're putting deals together and bringing money into those type of opportunities. When, from a limited partner standpoint, from someone who's investing in this type of deal, when should they be looking out for a PPM versus, hey, they're just investing in a deal with a friend that's out there doing a deal that requires some additional capital to make the deal work? Does that make sense?
It does. And the first thing to understand from a passive investor standpoint is that there is no exemption or no get out of jail free card just because they are they're it's a small deal, or because it's my friend, or because it's my parents, or that doesn't matter, right? It does come into play on the smaller deals, unfortunately. And maybe fortunately for me, because I get to put food on the table, but it's a little bit expensive. There's a compliance cost associated for a lead sponsor to put a syndication together. It costs quite a bit of money. And so if you're only doing like you mentioned, a 6-unit apartment building, and you need 60 grand or something, or 100 grand, or even 200 grand, it really doesn't, you can't really hire an attorney and do it properly, because the numbers just don't pencil out. I mean, if you're raising even $600,000, raising, not that it's the property's worth, you're actually raising 600,000, which probably means the property's worth, a couple $1 million or something, then the compliance cost kind of kills the deal. And so what you tend to see, and I think this is where you're going, David, is that you tend to see people trying to get around the securities laws in order to avoid that expensive check that they have to write. Because again, usually if it's less than $1 million or less than even 750, it may not make financial sense to do it. And so they come up all kind of excuses. But at the end of the day, as a passive investor, you need to ask yourself the following question. Am I simply writing a check and hoping that David can do his thing and provide me a return? Or am I an active investor, meaning I'm writing a check, but I'm also an experienced real estate person? I'm going to go in and I'm going to help with some renovating some of the units, or maybe I can market it, or maybe I'm an interior designer and I can, make the units all pretty, and so I can, whatever. If you are a little bit more active, then there's an argument to be made, if it's a small investment, a small group of people, that you're not really contributing the capital. Yes, you're contributing capital like everybody else, but you're really an active investor, and you're really partnering with 2, 3, 4, 5 people, and that's not a security. But if you're not doing any work, or not doing enough work to cover your, the amount of money that you're contributing, then that's going to be a red flag. And obviously in an investment, I mean, not obviously, but in an investment like that, where everybody's contributing, you're not going to see things like the lead sponsor making all the decisions, for example, because this is now more like a partnership. We call it a joint venture. Everybody should be have a vote and making a vote on at least the important decisions. And you wouldn't see things like, asset management fees, or all the kind of fees that are associated with the syndication, which are totally fine. In fact, you want your lead sponsor to make them, and they're doing all the work for you, so they're going to get paid to do all that work. So anyway, those are maybe some additional red flags in terms of a smaller deal. The same rules apply. The only way you can theoretically get around the securities laws is if every single person in that investment is actively involved. They're rolling up their sleeves and going to work, such that the returns of the investment are not going to be, based or generated by the lead sponsor. It's going to be generated by everybody's efforts.
Yeah, I like that last little piece there that you mentioned. Really, the red flag is if you are only putting money into a deal and you have no other involvement, no other decisions that are being made, no other efforts put in, no other time put in. You're not bringing any other resources to the table, and you're just putting money in with an expectation of a return, then there likely needs to be the legal structure in place to handle this type of deal, which would include the PPM, the private placement memorandum, which you referenced.
Yeah, and maybe an easy summary just to kind of encapsulate it all. Maybe we should have started with, but we talked about the structure earlier on. We actually talked about the structures I went through, and then your example of a structure. The structure itself does not matter when it comes to the securities laws. And so the definition, sort of the layman's definition I've come up with over the years is anytime you're taking money from passive investors where the returns are generated by your efforts or the sponsor team's efforts, that's a security. Whether it's debt, equity, joint venture, handshake, profit sharing, high five, doesn't matter. As long as one person or a group of people are generating the return, that's a security. And so the flip side would be what's not a security is when the returns are not generated by one person, but are actually generated by all of the investors, right? So if the returns from the investments are generated by everyone's efforts, then that's not a security. But generally speaking, you're going to have less than 5 people in that investment. You're not going to have an investment with 15, 20, even 10 investors. Usually the SEC has actually said that once you get to 5, it's a little bit hard for you to argue that everybody is, actively involved. There's somebody in there that wrote a check and is maybe, picking up the mail every day, and that's not going to cut it.
Yeah, love it. Well, staying on the limited partner side of things or the passive investor side of things in a real estate syndication, what sort of circumstances would give the legal right for a passive investor to recover any losses or their investment?
Yeah, well, the violating the securities law. So I wrote an ebook many years ago now. It was meant for, obviously, for syndicators, called The 5 Things Every Syndicator Must Know to Stay Out of Jail. And the reason I wrote it was kind of obviously an overreaction of the title, but I wanted to get people's attentions because a lot of syndicators, meaning lead sponsors, aren't really taking these securities laws seriously, or maybe in the situation where it's a smaller deal, they're kind of just like, let me get around it. The excuse I keep hearing is, well, everybody's doing it, so whatever, I'm just going to do it anyway. And so, but even though you're likely not going to go to jail as a sponsor, unless, if you're Bernie Madoff and you're ripping off your investors, you're going to go there. Right. But if you're not doing it intentionally and you're, whatever, the main penalty for a syndicator, and therefore the main recourse of a passive investor, is what we call rescission and restitution. Meaning, if I give you a $50,000 and I could have lost my money for no fault of your own from a market perspective. Maybe there was a fire, maybe the economy collapsed, and I lost the property. We lost the property to the bank. Really, we can't fault you for that because of whatever circumstances. But if you did not follow the securities laws and you violated the securities laws, my general recourse as a passive investor is I get all of my money back plus interest. Now, what generally happens, of course, is if the property's gone underwater and it goes back to the bank, the lead sponsor, let's be real, probably doesn't have the $1 million, $2 million, whatever, $5 million they've raised. And so they end up filing for bankruptcy and that may not be a great recourse for you, but that is the penalty for a syndicator who doesn't follow security. You end up with what we call an unregistered security, because remember, we have to register or we have to find an exemption or it's illegal. So if we don't register it, right, we try and do this little small deal and we say, oh, it's not a security. And then the SEC says, no, it is a security. Well, now you didn't register it, so you got a problem. Or if you're relying on one of these exemptions, let's say the 506B, and instead of, you're limited to 35, but let's say you get 36, or, you're prohibited from advertising, but you advertise anyway, then you end up again, you can't rely on that exemption. So you ended up again with an unregistered offering. It always goes back to this unregistered offering. You fail to register your syndication with the SEC, and the penalty for that is going to be rescission, which is restitution, interest, and then penalties, obviously, for me, financial penalties from the SEC or the regulator. And also you might be barred from raising capital ever again, or for the next 5 years, or depending on how severe it is. And obviously a lot of this is negotiated. It's very rare to see, not unheard of, but it's usually just like any other litigation. I used to be a litigator myself back in the day as well. When I was doing securities, I was doing litigation when I started. the vast majority of these cases don't go to trial, right? 95%, 98% settle. And the same thing happens here. You get accused, there's a lawsuit against the syndicator, you end up negotiating something, but that negotiation will include returning all the investors' money plus interest. What you're negotiating is the fine and maybe only being barred from raising for 5 years as opposed to a lifetime ban. But that's generally speaking the recourse, which, as you can see, isn't always a perfect scenario for the passive investor, which is why it's so important. Even though these are quote unquote passive, it's only passive once you write the check. Before you write the check, it's not passive. You've got to be actively involved and vetting the sponsor and getting to know the people involved, who's going to be running the show, what's the property. You probably don't have time to go fly and do your own due diligence, which is kind of saying the same thing, always going back to you've got to do your due diligence on the sponsor, because at the end of the day, if they can't deliver for whatever reason, yes, there's theoretically a restitution for you, but realistically, if it goes really bad, the sponsor is going to file for bankruptcy and you're going to be, SOL, as they say.
Well, and I appreciate you going into that. And, we could dive into some details about maybe some guidance on how to vet a sponsor, but ultimately, that's where the passive investor, as much as we want these to be completely passive investments, and I think that there's some room to say that, hey, once you've vetted a sponsor thoroughly and you've invested with them and had an experience with them, then it becomes a little bit more passive. But I love your encouragement to really be heavy and be active on the front end of an initial investment with a new sponsor that you haven't done a deal with in the past. Any thoughts on that?
Yeah, I mean, that's one of the reasons you see, if you have a good sponsor out there, it's a reason why investors keep coming back over and over again, because they don't have to go do the due diligence anymore. If you've done all that work the first time and you've vetted the sponsor, I would encourage people to, I know it's time commitment, but, go fly down to meet them in person, look at their operations, all that kind of stuff. Once you're satisfied and you make that first investment and it turns out that you were right in your due diligence and they're doing a good job for you, well, then it's just the next time it's just easier. Just write them another 50 grand, or when they return when you exit and they just give it back to them, because you don't have to do any of that work again. You've done it once. And so that's one of the reasons you see a lot of, once you do that for 2 or 3 different sponsors, then you're like, okay, good. I don't need to do this anymore. I can just write checks because I know these guys and gals well because I did my work.
Yeah, love it. Well, let's pivot a little bit in the time that we have remaining, and let's talk just about on the lead sponsor side of things. Tell us a little bit about any unique challenges that you're seeing bubble up in the industry, in the space. Maybe it is in relation to some regulation. Maybe it's in relation to what's going on in the market with a change in the economy. But I'm just interested in getting some insight from you if there is anything unique that's sort of bubbling up in the space, any new insight that you would like to offer to any of the lead sponsors that are listening right now.
Yeah, I think I'll tie 2 of them together because I wanted to talk about one thing, but it's starting to happen even more because of something. So, because of what's going on currently with, higher interest rates, with the stock market taking a tank, and just this overall fear, whether it's true or not, that, maybe we're heading into some cloudy times, it's getting a little bit harder to go raise the capital for lead sponsors. So that's the feedback I'm getting in general. It doesn't mean that we're not doing deals. It's just, instead of raising it in 10 days, now it's taking 3 weeks, or instead of, whatever. And so what tends to happen, and this has been happening for a while already, is that people are starting to look for help, right? They're starting to look for people, and there's plenty of those people out there that may be able to bring some capital into their deals in exchange for some kind of a referral fee or some piece of the deal, or just some form of compensation. And that's been a huge deal now for 4 or 5 years now. We called it, I keep forgetting the word because I almost want to say a pandemic, but obviously with what's going on, that's not a good word. I think I forget the word we're using, but it's so prevalent that it's becoming a really big issue. And what people need to understand from a lead sponsor standpoint is that just like I, as an attorney, need to have a legal license, just like, in order to practice medicine, you need a medical license. In order to go raise capital for other people, whether that's a cut of the GP, whether that's a check, whether that's, whatever, they have to be licensed too. There's a license out there, which is a broker-dealer license, and they have to go get that, which of course never happens. And so there's a ton of people right now that are either offering the services to lead sponsors, and you just got to be super careful that you can't just offer them anything, even a cut of your shares of your profit in exchange for somebody bringing them in, because that'll violate for them, for the person doing it. They don't have a license, and then what you're actually doing is actually compensating an unlicensed broker dealer, and you're obviously not disclosing that, or you're not putting that in your docs, and you probably don't think you're doing anything. So that leads to a failure to disclose issue as well. But that's kind of a big prevailing thing. The way that you have to, as a lead sponsor, which people are playing fast with these rules too, but the way you kind of, I don't want to say get around it, but the way you are able to
stay compliant
is making sure that they're not acting as a broker dealer. And that means three things. One, you're not paying them transaction-based compensation, because that's a hallmark. So the hallmark of broker dealer is, hey, I get you an investor, you pay me X, or I get you $1 million, you pay me 5% of the GP. But if I get you $2 million, you're going to give me 10% of the GP. So it's tied. If your compensation is tied to whether you bring in money and then how much you bring in, that's going to be broker dealer. So you can't do that. Then the person has to be actually doing real work. They have to be doing what we call substantial duties in the syndication, just like everybody else. They've got to be doing due diligence, underwriting, investor relations, whatever, all the things that everybody does, talking to the lawyers, all that stuff. They need to be doing that as well. And then their primary role, which to me means 50% or more, their primary role needs to be working on those duties, not raising capital. Right. So even though you may have substantial duties, if you're spending most of your time out there raising capital for the sponsor team, you're going to miss out on this little, not loophole, but exemption. And it's not really being an exemption. It's just structured in such a way that it's kind of like with the securities description before. It's not a security, therefore I'm good. Here, you want to make sure that the person that's doing all this work is not a broker dealer. And the way you do that is making sure you do those three things.
Yeah. Is there any other check boxes that could be marked in for a lead sponsor who's bringing in, we'll use industry jargon, a co-GP, a co-general partner into a deal? You mentioned doing substantial other duties, and you've identified 50%. I like that you're sort of putting a number on that, because it's such a gray area. And is there any of that 50%, what kind of duties are you seeing as being the ones that hold the most, that have the most teeth in solidifying their role as a legitimate partner in the deal?
The main thing the SEC is looking for is for co-sponsors, and some people don't even like to use the word co-sponsor, because it already starts making it look like there's a lead
right.
and a co. And so, but what they're looking for is to make sure that once the equity raise is done, right, you close on the property, you've raised all the money, now you're actually starting your turnaround strategy, or you're implementing your business plan, that all the sponsors are involved in that, what we would call the asset management piece. So the more you can be involved in the asset management piece, the better. So if all you're doing is getting involved in the front end and talking to investors and doing this, that, the other, and then suddenly you close and you're not doing anything or very minimal work, showing up to these, one of my favorites is, well, I show up to all these meetings every week with the property manager or something, just as if like just attending is sufficient. And again, it's all facts and circumstances. I mean, there's a difference between me showing up to a meeting every week and just hanging out, right? Or am I actually very actively participating in these meetings? Am I providing feedback or suggestions? And hey, this is an idea. We should be doing this. We should be doing that. Maybe I'm the one that's popping in without warning to the property to go meet with the property manager. Those are different types of things. So it's all facts and circumstances. What I think most people try and do, which I don't believe is enough, is just purely being an investor relations person. The main mistake I see there is I see multiple investor relations people, because everybody wants to be the investor relations with supposedly their group of investors, which again, you're already categorizing them, which is a mistake. So you only need one investor relations. So that one investor relations person should be, and again, facts and circumstances. If all they're doing is just receiving an email and forwarding it to the investors once a quarter with a report, that's not going to cut it. But if they're legitimately fielding all the questions, fielding all the complaints, if somebody needs a K1 or somebody, whatever it is that they need, that's who they contact. And then they're putting together the quarterly reports, and they're figuring out the distributions, or what they're actually doing work that may work. But if they're just simply, an investor relations and they're getting, 20% of the deal, how much does it really cost to go hire an investor relations person? $60 grand a year, $80 grand a year, maybe. So if this person's making $300,000 because they own 10% of the GP or something, it starts to not add up. So it's all facts and circumstances. I like to think of it as a sliding scale. The more, I would argue that the more cut of the GP you have and the more money you brought in, then the more substantial duties you're going to have to do. If you're simply a 2% owner, a GP, because you're spending the weekends and evenings, I've got a full-time job. My favorite is I've got a full-time job, but I'm an engineer, so I'm really good with underwriting. And so I spend my evenings and weekends helping you underwrite markets that you don't know anything about. And so, every so often we may get something. And in exchange for that, I'm getting paid 2% of the GP. Great. And if I bring in Joe or Sally, that's probably okay, 50 grand. But the same facts and circumstances where I'm working weekends and night, but all of a sudden I'm bringing in 80% of the money and I'm getting 25% of the GP. Well, I'm gonna have to do a little bit more than just do evening underwriting. So for me, it's a sliding scale.
Let me ask you a little bit more nuanced question about that. You see a lot of the structures where, and again, using industry jargon here, but you replace it with your favorite title. But let's say we've got a lead sponsor and there's some another co-GP that's involved in the deal, and he is playing a substantial role in the deal as a partner, but he's not being compensated through the asset management fee. Is that a red flag? Because you had mentioned that it's critical for them. Yeah, you had mentioned that it's critical for them to be a part of the asset management, the ongoing asset management of the deal. If they're not being compensated through the asset management fee that's being collected, is that a red flag? Is that an issue?
It would be a weird structure because generally, again, there's no fast rules, but generally when we talk about structures all the way at the beginning, generally speaking, the management team is in the form of its own. That GP is usually in the form of an entity, right? So there's a management company. That's at least the way we structure it. So the management company generally has the acquisition fees, the asset management fees, the refinance, any fees that show up is going to go to that management company. And if I own 2% or 5%, I should be getting a piece of that. If somehow you're outsourcing, you can outsource the property management. Obviously, that's what generally happens. But the asset manager is usually the GP. So I would say, yes, it's a red flag if that's not, if it's not the standard way, you're going to have to say, well, why? I would just keep keep asking the question, well, why? Why is it structured differently than the vast 90% of the syndication? And then as you keep digging deeper and deeper, you're probably going to find something that's a little, maybe not, maybe there's a legitimate reason. For example, one of the legitimate reasons is often one of the, maybe there's 3 or 4 sponsors, even if you just have 2 sponsors, to be honest with you, but maybe one of the sponsors doesn't have stellar credit. Maybe they don't have the net worth or the liquidity, or the bank just look at it. Look, they can't be managing the day-to-day, or at least be on as the manager of the entity, because we'd have to underwrite them. If we underwrite them, the sponsor's just not going to cut it. And so there are legitimate reasons why maybe they're not showing up as the manager, but they can still be the member of that management company, and therefore they should indirectly get that management fee or acquisition fee or asset management fee, because again, it's that, let's say it's a 2% asset management fee that's going to the company, and the company then generally will distribute that proportionally. And the management company, that proportionate ownership should mirror the sponsor. Like if I own 2%, or if I'm a 2% co-sponsor, I'm going to own 2% of that management company and get 2% of all the distributions.
Yeah, love it. Well, I've kept you longer than we initially anticipated. What I would say in closing is that Mauricio is a wealth of knowledge and experience. He's got a great YouTube channel on a weekly basis. He is going live and answering both passive investor and active investor questions all about securities. He brings on great guests. So if you haven't checked out his YouTube channel, go check that out. Mauricio, aside from the YouTube channel, what are the best ways for our listeners to connect with you and learn more about what you have going on?
That weekly Q&A, that's really, so you can sign up for that at mauriciorauld.com/live. That's to sign up for. And I, like you mentioned, it's usually a topic that I pick, and then we talk about it, and then I answer. I kind of do an open Q&A. So if you've got specific questions you want to ask me, that's a great resource. Our Facebook community is very vibrant. It's also mauriciorauld.com/FB group. for Facebook group. I spend most of my time during the day hanging out there. It's almost like a little networking and stuff. So those are probably the two best ways, plus a YouTube channel to get a hold of me. And would love for you guys to join and get to know you a little bit.
That's awesome. Well, Mauricio, pleasure to have you on the show. Thanks for coming in and sharing some insights on both the passive investor side of things as well as the lead sponsor side of things as it relates to securities and syndications. I appreciate you coming on, sharing the insight, and look forward to staying in touch with you down the road.
No, thanks for having me, and until next time.